Chip Cooper, founder of SaaS Marketer Pro and also a full-time practicing SaaS attorney. Now, this is the third in the series of GDPR videos, and this one deals with the data subject's right to be forgotten. First, a quick housekeeping announcement. The presentation is for informational purposes only. It is not legal advice. No attorney-client relationship will be created, and it's only a brief summary of the main points. So this question, very pertinent. What is the right to be forgotten? It's simply the right of a data subject to have the personal data deleted. Now, the general public knows about this term or generally refers to it as the right to be forgotten. However, the statutory language of GDPR refers to it as the right of erasure, meaning exactly the same thing. So here you see a bulleted list of GDPR Article 17, a list of the key bullet points of the statute itself, and you see that the title is Right of Erasure. Now, there are really two really critical takeaways here. And the first one is down near the bottom, one up from the bottom, the right of erasure, the right to be forgotten, is not absolute, meaning that you do not have an absolute legal obligation to delete when a data subject makes the request. Now, if you move up to the third bullet in yellow there, the process is initiated by a data subject who makes a request, either verbally or in writing, that personal data be deleted. That, of course, is the right of erasure. And it's also important to understand that you have a deadline. You have a month during which you need to respond. Very important that you understand, not necessarily that you have a month to delete the data, because drop down one to that bullet point that is underlined there, the words not absolute. It means that you may have circumstances where you're not required to actually do the deletion. You have the 1 month to respond with an explanation of why you're not going to delete or that you are going to delete. So this right is subject to exceptions, and we'll talk about that here. When does the right apply? It applies basically primarily in the circumstances indicated in yellow there when the consent is the basis for retention of this personal data. Then when the consent is withdrawn, then of course the right applies subject to the exceptions. And then dropping down 2 bullets again in yellow, if the processing is for direct marketing, whenever the data subject objects to direct marketing, again, the right of erasure will apply subject to the exceptions, which are critically important, and here they are. So we're going to focus on the 2 bullet points in yellow. A couple of these are rarely going to be concerned here. Number 1, for example, to exercise a right of freedom of expression or information, that sort of thing. We actually go down to the second bullet, which is in yellow. The right of erasure does not apply when you have the obligation to comply with a legal obligation to retain it, right? And then down at the very bottom, again in yellow, for the establishment, exercise, or defense of legal claims. So whenever these 2 circumstances arise, you need to comply with a legal obligation or establish, exercise, or defend a legal claim involving you, then you can take advantage of an exception to the right of erasure, meaning that you don't have the obligation to erase. Now, by way of explanation, look at the yellow text in the upper right. Here are 2 examples that would qualify you as an exception for the right of erasure. One would be if the Internal Revenue Service, for tax purposes, legally requires you to maintain certain information that involves retention of personal data, then the exception applies to you. You don't have an obligation to delete. And then secondly there, regarding unsubscribed suppression lists. Now, a suppression list is a list of people who have actually unsubscribed to your email. And the federal statute CAN-SPAM requires you to maintain the list of unsubscribers in order to honor their request. So you now have a legal obligation to retain the suppression list, and of course this again would be one of the exceptions to the right of erasure. So another question that's related is, what is data mapping? Because data mapping involves how you prepare yourself for the exercise by a data subject of the right of erasure or deleting data. And the clue there in parentheses is, where is your data? You're not going to be able to delete it unless you know where it is. That's really the key to it. So the data mapping process is really the process of preparing yourself to delete data if you have to. And here are the key points. You need to understand where or what the data items are that are involved in a request to delete: name, email, address, that sort of thing. Secondly, the data format. What format is the data in? Hard copy, digital copy, etc. And then third, the transfer methods. Has the data been transferred internally to your organization or externally to it by phone, etc.? Very important. And then finally, critically important in summarizing the process, where is the data stored? In your office, in the cloud, third parties, that sort of thing. So the whole process of data mapping, which is preparing you for a deletion, involves a lot of research regarding these 4 basic points. Now, there is a possible related issue here regarding GDPR Article 30, requiring you to keep very detailed records of processing activities. However, if you notice at the very top, there is a red asterisk, and then if you go to the very bottom, you'll see the follow-up asterisk that indicates that your obligation to maintain this very detailed record of processing activities doesn't apply if you have fewer than 250 employees. So this probably wouldn't apply to you, but it is presented here because it's a very important obligation that some processors have to undertake. And if you look at this list here, it'll give you some idea of how detailed the data processing activities record keeping is. Contact information, purposes of processing, categories of data subjects, personal data, categories of recipients, what are the countries where it's located, that sort of thing. An incredible amount of record keeping, very detailed. And of course, if you qualify for that bullet point, the red one at the bottom, where you have fewer than 250 employees, you don't have to engage yourself in all of these very burdensome requirements. Now, how do you go about the process of data mapping, which of course is the preparation for erasure? There are a number of automated tools out there to assist you. Here is one example here where you have a software-based automated tool that assists you in this very laborious task. Here's another one that is flowchart oriented. And so this gives you some idea about how to go about doing it. Now, I know that some of my clients, very small clients, have used a spreadsheet in order to do their data mapping in order to prepare for the right of erasure, and that will work with very small businesses. But if you have a larger business, you're probably going to have to invest in some sort of automated tool in order to get the job done. So again, the question in summary is, do you need an attorney for GDPR compliance? And of course, the answer is yes, you do. And the reason is compliance is complex, a lot of regulation, and the compliance is just more than documents themselves. There are a lot of things you need to do regarding privacy and data security. However, SaaS Marketer Pro provides the documents for you, and I believe very clearly that these documents will help you get started and save you a lot of time and some serious money. So this is the final slide in this presentation. Quick follow-up housekeeping announcement. You will need an attorney, and if you'd like to engage me in a conversation about whether you might want to work with me on an attorney-client basis, all you have to do is email me at that address, digicontracts@gmail.com.